Morning, it is 10 a.m. on May the 14th, 2013. At this point in time, I'll call the State of Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers to order. I'll ask Ms. Lisa Mosby to call the roll, please.
Lane Hinkle.
Here.
Tony Highsmith.
Here.
David Neal.
Here.
W.T. Patterson. Jane Grace Sowell. Robert Starkey.
Here.
Anita Taylor. Here. Mr. President, everybody's accounted for except for Mr. Patterson and Ms. Sowell.
Thank you, Ms. Mosby. We do have a quorum present. At this time, the chair will entertain a motion to adopt the agenda for today's meeting.
Go ahead. Make a motion.
Second. Motion made by Mr. Starkey, seconded by Mr. Hinkle to adopt the agenda for today's meeting. Any further discussion? All in favor say aye.
Aye.
Any opposed? The chair wishes to suspend the approval of the April minutes. We will do that at the beginning of our June meeting. So at this point, we'll turn our meeting over to our legal report. Mr. Bent McDonough, Assistant General Counsel, for our legal report.
Mr. President.
Just a moment, Mr. Bent, please.
Mr. President. The first complaint is case number 2013-000591. Case number 2 is case 2013-000592. On January 3rd, 2013, the funeral board received a complaint regarding the complainant. From the complainant. The complainant alleges that the respondent was arrested and charged with reckless endangerment and aggravated domestic assault on November 4th, 2012. A police report provided to the board counsel shows that on November 4th, 2012, the respondent's wife contacted local police regarding an incident that took place on October 28th, 2012. The wife alleges that during the incident, the respondent pulled a weapon and fired the weapon into the bedroom wall. In the report, the police noted that a bullet hole was visible in the bedroom wall and curtains. Based upon this interaction, the police took the respondent into custody. However, the respondent made no comments after his arrest. Respondent provided a response through counsel. Respondent stated that it should be noted that the complainant is a direct competitor of the respondent, and the respondent believes the complaint was filed for an improper motive. The respondent sent a cease and desist letter to the complainant concerning certain alleged improper activities on the part of the complainant. And as for the substantive issues addressed in the complaint, it appears that the complaint is that certain misdemeanor charges were filed against the respondent. These charges arose from a domestic difference of opinion and have since been resolved. Respondent states that it is anticipated that the pending charges will be dismissed in full with no action against respondent at the next court hearing. Charges arose out of a misunderstanding, and the parties have now come to a more complete understanding of the situation and reconciled their respective views and relationship. According to respondent, the next court appearance is set for May 15th, 2013, and we found a history of one closed complaint. And we're recommending for, in both situations, a litigation consent monitoring order, and that in the event that the charges are dismissed at tomorrow's hearing, that the complaint be dismissed against the respondent as well, against both respondents.
Motion, we accept council's recommendation.
Second. Motion made by Mr. Starkey, seconded by Mr. Hinkle to accept council's recommendations. Any further discussion? All in favor say aye. Aye. Any opposed? Motion carries.
Number 3 is case 2013-00401111, and case number 4 is 2013-00401112. Respondent contacted the board director on February 14th, 2013 to advise that the respondent has a felony conviction regarding theft. The respondent has not reported the conviction to the board. respondent plans to report the conviction to the board within the next few days by sending a narrative of the incident and copies of documents from the clerk of the court. And the respondent intends to renew the funeral director's license and embalmer's license. In response, the respondent notified the director of these convictions, but failed to provide the narrative as requested, and he never renewed his license. We found no prior complaints, and I'd like to instruct the board that yesterday I contacted the clerk's office in the county where these actions reportedly took place, and at this point, the respondent was placed on judicial diversion for one of the cases and had a misdemeanor conviction for another one. And based on that information and further investigation, I believe that the proper course of action is to dismiss both complaints, as there is no violation, as he was not required to report either one of those based on the rule that's currently in place by the board.
Motion to accept council's recommendation.
Second.
Motion by Mr. Hinkle, seconded by Mr. Starkey to accept council's recommendation. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 5 is case 2013003531. The complainant states that she had money taken out of her insurance check that she did not approve, but was told that the funeral director approved the action. The funeral home owner had the family sign blank pages and told them that this would not affect their money. The stepmother was supposed to pay for the funeral in full. In response, respondent states that these allegations were not true, as there was a miscommunication between the stepmother and the children regarding arrangements. After all the paperwork was completed, the children changed their mind regarding paying their part of the bill. The matter has been resolved, as the stepmother reimbursed the children and all funds have been properly refunded. Also, the stepmother sent in a response on behalf of the respondent as well, and the stepmother wrote that all the beneficiaries had agreed to $800 being withdrawn from their insurance checks. However, she decided to pay the money on behalf of the children and reimburse them all of the money that was taken out of the payments that they received from the insurance check. And we found a history of 4 closed complaints in this matter, and we're recommending that this case be dismissed as well.
Council's
Second.
recommendation.
Motion is made by Mrs. Taylor, seconded by Mr. Neal to accept council's recommendation. Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 6 is case 2013004201. The complainant's mother died on January 30th, 2013 in Louisville, Kentucky, and he contacted the respondent funeral establishment to handle the services in Tennessee. The complainant spoke with the respondent regarding removing the decedent back to Tennessee and burial at a local veterans cemetery. The respondent provided a charge of $100 for removal plus $1.75 per mile. The complainant stated that he would be in town in the next week to make final arrangements. The complainant arrived February 6, 2013, and met the funeral director and delivered clothes for his mother. The respondent gave a price of $6,195 for the services selected by the complainant, but the complainant decided to go with another funeral home for a third of the price. The respondent provided charges of $2,053 for services already rendered before the body could be transferred to the new establishment. The complainant acquired the funds, but the funeral director, other staff, and owners of the establishment said that they are not responsible for making such arrangements. The complainant then decided to contact the police because he was unable to get a response from the respondent and believed that they were holding his mother's body. The complainant informed respondent of his contact with the police and informed them that he was going to proceed with a memorial service for his mother if the respondent failed to release the body. This all took place 11 days after the respondent took possession of the body. The complainant then met with the funeral director and secretary, who provided a bill that included $1,295 for services provided by the funeral director and staff and $758 for transporting the body from Louisville. In response, respondent states that they removed the body and received permission to embalm the decedent's body. On February 7, 2013, the funeral director met with the complainant and presented him with the embalming authorization form and general price list. The complainant gave vital information and the funeral service particulars and then looked through the casket catalog. The complainant picked a casket of his choice and color and selected an outer burial container after he had finished. The office manager typed up the bill, which was signed by the complainant and funeral director. The respondent explained that they do not accept out-of-state checks, credit cards, or term payments, and that the bill must be paid in full prior to funeral services being rendered. The complainant left and stated that he would return with the funds, so the respondent ordered the merchandise and a plot at the local veteran cemetery. Several days passed without any communication from the complainant, so the respondent contacted him and learned that he chose a different funeral establishment. The respondent then canceled the merchandise and the plot, but provided charges for the services rendered, which included housing the decedent's remains. The bill provided to the complainant did not include charges for burial, but only charges for services rendered by the establishment. We found a history of 1 open complaint and 9 closed complaints involving this respondent, and we're recommending a consent order with a $750 civil penalty and authorization for a hearing.
Did the funeral home hold the body until the money was paid, or what's?
That's the way it sounds like it was portrayed to me. Although I think there was a matter of time that passed during which the complainant decided to choose another funeral establishment. It doesn't sound like that they necessarily informed the respondent at that time that they were going to go find another establishment and they wanted to release the body.
Last complaint shown on the complaint list, operating on expired license, has that been taken care of? It's shown as open.
Yes, that's been taken care of. They're
That's actually a
they're current.
They're current.
They renewed their license, but that they haven't necessarily signed the consent order or paid the civil penalty.
What is the penalty for? Sounds like the funeral home did everything right here to me. I don't know. They only charged for what they did. You know, the charges seem legitimate. So why are we finding him a civil penalty of $750?
I think we went with that because we felt like they weren't being as responsive as they should, because he did, contact them and tried to set up, a payment and everything, but I think the $750 was because it sounded like they were giving him the runaround as far as whether or not, how he was going to make the payment.
They didn't want to work with him, in other words. Yeah.
They didn't want to work with him, and they weren't willing to. It sounded like no one wanted to take responsibility for sitting down and working out how the payment would be made.
How could you make a payment? We won't take a check, credit card. We
Right.
just take cash. Motion to accept council's recommendation.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Neal to accept council's recommendation. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 7 is case 2013-004301. The complainant's father passed away on December 25th, 2011, following time in a hospice facility. On Monday, November 14th, 2001, the complainant met with employee number 1 to pre-plan the funeral services. The complainant selected the veterans package, which allowed for a glossy brown wood grain casket with a smooth surface and cream-colored quilted satin lining known as copper hammer tone with rose tan satin interior, and employee number 1 informed the complainant that she could pay with a credit card at the next meeting. At the next meeting on Friday, December 9th, 2011, the second meeting with employee number 1, who proceeded to inform the complainant that she was in error at the previous meeting and informed her that the veterans package only allows for a glossy gray casket instead of a glossy brown. However, the interior lining would be the same. Furthermore, employee number 1 then informed them that they were not allowed to pay with a credit card, which caused the complainant to have to schedule a third meeting so that her mother could bring the checkbook to pay for the services. On Tuesday, December 27, 2011, 2 days following the death of the decedent, employee number 1, who assisted in the pre-planning of the funeral, was on vacation during that time, causing the complainant to have to meet with employee number 2. Employee number 2 assisted in finalizing the funeral arrangements and funeral and burial arrangements and made a copy of the Army discharge papers. On Monday, January 2nd, 2012, the complainant and her mother had visitation with the decedent, but realized that the casket was not the same casket they ordered, as instead of being smooth and glossy, the gray casket was rough and unglossy, and the lining was snow white and unquilted rather than cream-colored quilted. Employee number 2 tried to claim that the lighting in the room was causing the casket to appear different, but later admitted that it was in fact a different casket. Employee number 2 asked if the complainant intended to sue the respondent and was able to obtain permission to provide $200 in a refund for the casket. On Tuesday, January 3rd, 2012, employee number 2 met with the complainant prior to the funeral service and apologized for the error relating to the casket, and also apologized for employee number 1 who incorrectly completed the paperwork and, in their words, was prone to errors. The complainant was later upset because employee number 2 offered to provide the complainant and her mother with coffee, but later recommended that she walk across the street to the Sonic when employees complained about a shortage of coffee that day. Employee number 2 informed the complainant that during the arrangement sessions that her father could receive a 21-gun salute at the cemetery, but that never occurred, and a manager at the cemetery informed the complainant that such a service has not been performed in several years due to the Iraq War depleting the resources. As for the casket refund, the complainant states that she was told a $200 refund would be provided due to the error related in the casket provided for the decedent. However, it took 31 days for the refund to be provided. As for death certificates, the complainant incurred a charge of $35 from the respondent for 5 death certificates, with an additional 3 that were complimentary. However, the complainant had to make several trips to the treating physician's office and called the health department before learning that the respondent had the death certificates. The complainant called the respondent on numerous occasions, and the respondent stated that they were rewriting the certificates and would provide copies ready on February 7th, 2012. The complainant called several times on February 7th and several days afterwards with no response from the respondent. The complainant was able to speak with employee number 2, who she says then yelled at her regarding questions about the certificates, and then the manager of the funeral establishment called the complainant's mother and was rude to her. The complainant eventually went to the health department and took possession of 5 death certificates and later went back for the 3 complimentary certificates. The respondent later provided a refund of $35 for the death certificates. In response, employee number 2 responded on behalf of the respondent establishment and explained that the funeral home came under new ownership in April of 2012. The previous manager of the establishment is now living in Chicago, and employee number 1 is no longer working in the funeral industry. The complainant received the only casket that was provided through the veterans package. The respondent is very sorry if employee number 1 came across as confused, but respondent entered the information that was on the statement of funeral goods and services selected and ordered the silver hammer tone as it was written on the statement. The respondent did provide a $200 refund due to the issues surrounding the casket, but they were not privy to when the general manager actually mailed out the check to the complainant. As for the coffee, the respondent states that the manager was tight on the budget and supplies, therefore it was recommended that coffee could be obtained just feet away from the establishment. As for the 21-gun salute, the respondent states that they have never told a family that a 21-gun salute is provided unless the individual retired from the armed services, and they are at a complete loss as to why the complainant believes such service would be provided. The death certificates were provided at a cost of $7 per document, which came to a total of $35 for all 5, plus an additional 3 certificates that were complimentary. Also, a refund was provided for the death certificates, but respondent can't remember this being an issue in the past. As for the yelling at the complainant, the respondent states that they have never yelled at a customer, but did speak very directly to her and could have been perceived as yelling at her. We also received a letter from the new ownership of the respondent establishment. The vice president for the new ownership provided an apology to the complainant and informed her that the timely filing of death certificates has been a problem in the past and is something that they are working on improving. And we found a history of 9 closed complaints under the previous ownership. And our recommendation is that while several issues appear to be present in this complaint, the establishment is currently under new ownership. Therefore, council believes that the proper course of action is to dismiss this complaint, as it appears the new ownership is taking appropriate steps to address these matters.
Make a motion, we accept.
Second.
Motion is made by Mr. Starkey and seconded by Mrs. Taylor to accept council's recommendation. Is there any further discussion? All in favor say aye. Aye. Any opposed? Motion carries.
Number 8 is case 2013004501. The complainant filed a complaint against the respondent on February 22nd, 2013. The complainant's friend was an employee of the respondent funeral establishment and failed to receive payment for his services, which totaled $7,500 over several months. The employee was upset and went to the manager to inform him that he would be looking for work elsewhere. The manager then asked the employee to stay and told him that he would have payment the next month. The next pay period, the employee received compensation in the amount of $800.50, and the manager informed the employee that his services were no longer needed. The manager informed him that he would contact him for work in the future, and the complainant stated that the manager wanted to use the employee's license and list him as the manager of record. That way they could call him into the office when a field representative came for an inspection, and it would appear that the manager had just stepped out for the moment. In response, the respondent manager, a different manager than the individual noted by the complainant, states that he cannot respond to the complaint as he is not familiar with this particular situation. We found a history of 1 closed complaint and 2 open complaints, and we're recommending that this case be dismissed.
Make a motion, we accept.
Second. Second.
Motion made by Mr. Starkey, seconded by Mr. Hinkle to accept council's recommendation. Is there any further discussion?
Why is the complaint still open from 2011?
That would just mean that they haven't sent in the consent order or paid the civil penalty. But they're
How long can this go?
It would just depend on when the cases can be heard, because it's currently, believe
well-
it's set for litigation at this
Okay.
point.
Have a motion and a second. All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 9 is case 2013004881. On February 4th, 2013, a field representative conducted a routine inspection of the respondent establishment. During this time, 3 files were found to be incomplete. The cremation authorization form of Cynthia Harrell was not signed by a funeral director. The cremation authorization form for Jean Melton was not signed by a funeral director, nor did it have the signature of an authorizing agent. And the cremation authorization form of Jerry Wayne Bagwell did not have the signature of an authorizing agent. 3 files lacked a record of a receipt for release of the cremated remains. Those files included Cynthia Harrell, Jerry Wayne Bagwell, and Kathy Margaret Foster. A respondent had several issues with their price list. The casket price list, the caption must be corrected to read casket price list. The outer burial container price list, the caption must be corrected to read outer burial container price list. And the casket price list under direct cremation, the alternative containers being offered to the consumer do not agree with the general price list. Also, the Statement of Funeral Goods and Services selected. The program that produces contracts and is utilized by the respondent produces misleading information that is printed on the Statement of Funeral Goods and Services selected, as some figures are not needed as they come from no reasonable source within the document. And in response, the respondent admits to everything in the complaint with the exception of Cynthia Harrell and Jerry Wayne Bagwell's files lacking a record of receipt for release of cremated remains. And the respondent corrected the other matters and provided verification of those corrections. We found a history of 7 closed complaints, and we're recommending a consent order with a $500 civil penalty and authorization for a hearing.
Make a motion, we accept council's recommendation.
Second.
Motion's been made by Mr. Neal, seconded by Mr. Starkey to accept council's recommendations. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 10 is case 2013-004891. On February 7th, 2013, a field representative conducted a routine inspection of the respondent establishment. As for the utilization of a crematory, one file lacked the signature of a licensed funeral director on the cremation authorization form. The receipt, 23 files lacked a receipt of human remains delivered to the crematory with correct information in the cremation files required, and 3 files lacked a receipt entirely. As for the funeral rule violations on the casket price list under direct cremation, the alternative containers being offered to the consumer do not agree with the general price list, and the statement of funeral goods and services selected of the files checked, one statement did not have the reason for embalming completed. We received no response in this matter, and we found a history of no prior complaints. And we're recommending a consent order with a $500 civil penalty plus $250 for no response, for a total civil penalty of $750 and authorization for a hearing.
Motion to accept council's recommendation.
Second.
Motion is made by Mrs. Taylor, seconded by Mr. Neal to accept council's recommendation. Is there any other discussion? All in favor, say aye.
Aye.
All opposed? Motion carries.
Number 11 is case 2013-004911. On February 13th, 2013, a field representative conducted a routine inspection of the respondent establishment. For the cremation authorization form, the file of Doris B. Abney had a cremation authorization form, but it was not signed by a funeral director. On the statement of funeral goods and services selected, 11 files did not have the merchandise and its description listed on the contract of the statement of funeral goods and services selected that were sold to the consumer as required. As for changes, the establishment must change the name listed on the contract for statement of funeral goods and services selected to agree with the exact name listed on the establishment application approved by the board. In response, as far as the cremation authorization form goes, the respondent states that a funeral director did sign the referenced authorization, but overlooked one of the multiple blanks requiring signature and therefore failed to completely execute the document. As for the description of merchandise, respondent states that this was an oversight and was the result of a computer programming error. The error was brought to the funeral home's attention until an inspection it was not brought to the funeral home's attention until an inspection at an affiliated funeral home last June was rectified. The issues in this complaint predate the last summer's inspection when this matter was first discovered and addressed. And as for changes, the respondent states that the statements included the majority of the respondent's name, but was missing a Y at the end of one word and then funeral home. This violation is related to a printing glitch that respondent is working to resolve. We found a history of one closed complaint, and we're recommending a letter of warning in this case.
Issues in this complaint predate last summer's inspection when this matter was first discovered and addressed?
Yes, this was a matter that was actually previously addressed with the funeral establishment, with the parent company, and it was a matter that we addressed with their counsel, and that based on the findings in this inspection, it appears that the information that they found in the inspection predated that before they could make the corrections. So,
Motion to accept council's recommendation.
Second.
Motion made by Mr. Hinkle, seconded by Mrs. Taylor to accept council's recommendation. Is there any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 12 is case 2013-005611. The complainant, who is a competitor of the respondent, filed a complaint on March 12th, 2013, regarding a newspaper advertisement placed by the respondent where cremation services were purported to start as low as $1,595. However, the respondent failed to provide an itemized price listing of each and every item, procedure, or service. In response, the respondent states that this advertisement was immediately pulled once the respondent was notified of the complaint. Respondent admits that the advertisement was out of compliance, and the advertisement was the respondent's first price point advertisement, and they were unaware that a description of services and prices for cremations must be itemized. We found a history of 5 closed complaints, and we're recommending a consent order with a $250 civil penalty and authorization for a hearing.
Accept council's recommendation.
Second.
Motion made by Mrs. Taylor, seconded by Mr. Neal to accept council's recommendation on number 12. Are there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 13 is case 2013-006111, and number 14 is case 2013-006112. On March 15th, 2013, a local news station published a story regarding the respondent funeral establishment. The report states that respondent number 14, who is an apprentice funeral director, posted a controversial picture on a social media website called Instagram, which shows him holding a sign that reads "Whites Only." According to the news story, this picture surfaced on Instagram just one day after the family of an African-American decedent had deceased human remains taken to respondent number 13. On Friday, March 15th, 2013, the family had their loved one moved to another funeral establishment where they would feel comfortable saying their final goodbye. Additionally, there was concern as to whether the family had to pay an extra $850 to move their loved one to the other funeral establishment. In response, the respondents state that respondent number 14 found the phrase "whites only" written on a paper towel and folded up in a break room or a restroom. Respondent number 14 brought the sign to a group of individuals congregating outside the break room, including the complainant, who is a local competitor and African-American funeral home owner, and all individuals present laughed about the ridiculousness of the sign. The complainant laughed and asked to take a picture of respondent number 14 with the sign, and the complainant was the only individual to take a photograph of that sign. Several years later, respondent number 13 and number 14 received word that families in the African American community were receiving text messages containing the photograph and asking, "Is this the way you want your loved ones to be treated?" The respondents believed that this was retaliation from the complainant, who at one point was close friends with the respondents, and both parties helped each other out on occasion. However, respondents and the complainant have had a falling out, and the respondents believe this activity was due to the respondents providing funeral services for 21 African American families in the community. As for the $850 charge to the one family, the respondents state that the family believes the respondents' stories regarding the sign, but believed it was better to use the services of a different funeral home. The respondents also state that the $850 resulted from $150 for removal and a $700 charge for embalming, which the family paid for and agreed to. As for respondent number 13, we found a history of 3 closed complaints, and respondent number 14, we found a history of no prior complaints, and we're recommending that both these matters be dismissed.
Example why you don't put your silly face on any kind of website. Instagram.
Make a motion we accept council's recommendation.
Second.
Motion made by Mr. Starkey, seconded by Ms. Tinkle to accept council's recommendation. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 15 is case 2013-006201. On March 16th, 2013, a letter of inquiry was sent to the respondent seeking information as to whether a Tennessee licensed funeral director was present and in charge during the committal services and interment of the decedent at Calvary Cemetery on Tuesday, February 19th, 2013. In response, the respondent apologized for being misinformed regarding burials in other states. They understand that the board must proceed with the complaint process, but ask that the board show mercy in its final decision. We found a history of no prior complaints, and we are recommending a consent order with a $350 civil penalty and authorization for a hearing.
This from a funeral home out of state coming
Yes.
into Tennessee?
Yes, that's correct.
Okay.
So they did not have, the funeral home from out of state did not have a funeral director on site, or they're saying they did not have a Tennessee funeral
We
director?
do not have a Tennessee funeral director, and they were completely open and honest about the situation as well once we asked them about it.
Actually, they actually made a mistake, so to speak.
Correct.
Are we asking for $350?
We feel that's appropriate in this matter.
President, a little bit of history is from time to time the field reps go and check this. And another way we found to save, in the history of the board is when the field reps goes and checks it and there's someone that brings a funeral in that doesn't have a Tennessee funeral director, previous board history has been that there's a consent order with a $500 civil penalty. Well, we decided it's more effective to just watch the internet or watch the newspaper and to send them a letter once they come into the state, just send them a letter and ask them, did you have a Tennessee funeral director, and if so, who was it? And then if they don't respond, we open the complaint. If they respond and they didn't have one, then we open the complaint. If they respond and they tell us that they had so-and-so, and then we can verify with them that they did, then we don't open the complaint. So since we didn't actually send a person to do the actual inspection, so to speak, or investigation, we thought it was appropriate to not charge as much civil penalty because we don't have the time and resources of a field representative.
Motion to accept council's recommendation.
Motion made by Mr. Hinkle, seconded by Mrs. Taylor to accept council's recommendation. Any further discussion? All in favor, say aye.
Aye.
Motion carries.
Thank you, Mr. President.
Thank you, Mr. McDonald, for your report. The chair now will recognize Mr. Robert Gribble, Executive Director, to discuss administrative matters.
Hey, Mr. President, thank you. Before I get into the things that I have on the agenda, one thing of just information, this board has talked quite a bit about the removal services bill that was in the legislature this year, and it passed both the House and Senate. It's been transmitted to the governor and checking information last night. That bill has not been signed, but it's expected to be signed. The effective date of the bill is January the 1st, 2014, as far as when these firms are required to register as a removal service. But once it's signed into law, then it gives the board rulemaking authority at that point. But as of today, it's not been signed, so there's not a public chapter assigned to it yet. Just wanted to make you aware of that. That's something we'll probably need to be looking at in the next few months as far as rulemaking, because the bill does give this board authority to do rulemaking for that. So just want to make you aware. First thing I have on the agenda is the licensee report. This is a report of licenses administratively approved by the Executive Director pursuant to the Board's authority for the period of April 9, 2013 through May 13, 2013. Establishments: Covington Funeral Home in Covington, Tennessee, a change of ownership. Patton Brothers Funeral Home in Nashville, change of ownership. One Funeral Home and Cremation Center Incorporated in Chattanooga, changes of ownership and name. Williams Funeral Home and Crematory in Columbia, change of location. Individuals who have been issued a license: a funeral director's license was issued to Kerry Wayne Boshears of Mount Pleasant, Tennessee. Closed establishment report. One establishment has reported closing since the last board meeting. That was Curry's Funeral Home in Alamo, which is located at 386 West Church Street in Alamo, Tennessee. Action report. This is a report of consent orders administratively accepted and approved by the Executive Director pursuant to the Board authority for April 1 through April 30th, 2013. Have 8 consent orders there. Total civil penalty of $7,000, and that is the open complaint report. As of May 10, 2013, there were 123 open complaints. 0 against apprentices, 6 against funeral directors or embalmers, and 117 against establishments. President, that concludes my report.
Chair will entertain a motion to approve the Executive Director's report.
So moved.
Second.
Motion made by Mr. Hinkle, second by Mr. Neal, to approve the Executive Director report. All in favor say aye.
Aye.
Any opposed? Thank you. Next item on our agenda is approval of license applications for individuals and establishments. Everybody a chance to get to that area.
Excuse me.
Mr. Gribble, do these individuals wish to appear before the board?
Yes, Mr. Leslie, if you'll come up and have a seat, I guess, to your left there, and here at the end, and just pull that mic down. And yes, sir. This is Mr. Brittany Jean Leslie from Tennessee Ridge, Tennessee, who is a reapplicant for a funeral director and embalmer's license. And the reason he is before you today is based on the application. The board may, among other pertinent statutes and rules, specifically examine Tennessee Code Annotated 625317 in making a determination whether or not to issue his license. Leslie was previously licensed, but this board let his license expire and has met all the qualifications to become licensed again. He may want to.
Leslie, if you will, give us a moment to review your application, please.
Leslie, are you presently employed with the funeral establishment?
I'm working in Louisville, just working with a helping embalm. Trying to get my license back.
Working in Louisville, this is not by reciprocity, but by Tennessee application.
A reapplication. Yes, he was once licensed, and I might say this on his behalf too. From the time his license lapsed and he's made reapplication, at one time the law required an embalmer to have a associate degree, and it wasn't. It didn't read like the funeral director's law. So when he inquired, that was the way it read, and so he has actually gone back to school and upgraded from a diploma to an associate degree during this time his license has been lapsed. And of course, the way the law is now, it's since been changed, and it's not required to do that. But he's fulfilled all of his requirements, and even is in a better educational position today than he was when his license lapsed. And he also did his continuing education. He's done everything that.
Motion to approve.
Second.
Motion to approve Mr. Leslie's reapplication has been made by Mr. Hinkle. Multiple seconds. The chair will recognize Mr. Starkey's second. Is there any further discussion? All in favor of the approval of this reapplication, say aye.
Aye.
Any opposed? Motion carries.
Good luck.
Thank y'all.
President, the next one is Robert Scott. I may mispronounce his last name, Paulus, of Church Hill, Tennessee, who is a funeral director and embalmer by reciprocity. He's seeking licensure here in Tennessee as a funeral director and embalmer, and he's been notified that the board will look specifically at Tennessee Code Annotated 625311B1 and B3 and Rule 0660-2-.023 and making a determination as to whether or not he meets the requirements for licensure today. And specifically, what we're discussing is on his national board score on the science section, he made a 74.8. On his arts section, he made 86, and back at the time he took these tests, prior to 2004, the conference averaged those scores, so he has an overall average which exceeds 75. Of course, their law says that, and rule says that you must make 75 on each one of those tests, and historically the board has rounded up 74.5, anything there above, to a 75, and taken care of that. Now, he has a letter in his file. He does not have an associate degree, so he has a letter in his file saying that he was employed from 1999 to 2008 with a funeral home in Redford Township, Michigan. We may want some information as to what's been his employment subsequent to 2008. He's licensed in the state of Michigan. He's been licensed there since January 17, 1986. His license is current, and it's been continuously renewed and does not expire until October 31, 2013. So basically there are two things, the 74.8 and the employment subsequent to 2008.
What did you do between 2008 and now? Worked in the funeral business or out of the funeral business?
Yes, sir. I've been in the funeral business since 1983. But from 2008 I was asked to leave because their business was dropping drastically. I actually took a leave of absence from the industry, kept my license current, was active in another industry altogether, came back into the industry in March of 2010, where I worked for the Chopek Funeral Home in Wyandotte, Michigan from 2010 until I sent my applications down to the East Tennessee area, and Carter Trend of Kingsport responded to that application back in October of last year.
Working in Kingsport now, or will be?
I am in Kingsport now, sir.
Okay.
Moved down on March 2nd.
Are we voting on this individually or each thing or just jointly? Or does it?
Just jointly, it's just the
Okay.
total application. Just happen to be two parts of it to bring to your
Was
attention.
that 74.8, that we've had that issue before. I'm going to make a motion to approve.
Second.
Motion has been made by Mr. Hinkle to approve this application. It's been seconded by Mr. Starkey. Is there any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Good luck and have a good day.
Thank you, ladies and gentlemen.
When I came in.
Mr. President, the next one to appear before the board is Ms. Doris M. Colvin of Estill Springs. Her application is for an apprentice funeral director registration. She's seeking this, and based on the application, the board may, among other pertinent rules and statutes, specifically examine Tennessee Code Annotated 62-5-312B4 and making a determination. Ms. Colvin, if you want to come on up. And legal counsel has some additional information about this. And as you know, it's very unusual to ask an apprentice, someone who's wanting to register as an apprentice funeral director, to come before the board. But we received this application. We responded in the office by contacting Ms. Colvin and asking her if she could provide any additional documentation other than what was provided at the time of the application. And she did provide some additional information at that time. Then we went to our Assistant General Counsel and discussed it at length, and he has worked on it, and he'll have some things to add when I finish. But I want to say that we thought it was the best thing to do, because all I'm to do administratively is to approve a routine application. And this doesn't fall within those lines. And we hated to ask her to drive from Estill Springs, which is close to Winchester, that's where she works at, to the board meeting today. But yet, we didn't feel like it was something that I could approve or deny, and she needed to come before the board and let the board make a decision.
If the board will look at 625312, one of the requirements under B4 is that the individual has graduated from a high school or has earned a GED recognized by the State Education Department. And we contacted the Department of Education regarding the school that she listed, called the Bible Light Christian Academy. And the department informed us that this particular school is not on their list of schools in the state. I know it's my understanding that the school is no longer in business, and they informed us of that matter. But also, Ms. Colvin has provided us with documents that came from the juvenile court of Coffee County that believe charges were brought against several parents regarding truancy matters with Ms. Colvin and several other individuals when they were attending the school, and the court dismissed those charges that the school system brought against these parents, or that the district attorney, I guess, brought against them for truancy. So. At this time, if you all would like to ask Ms. Colvin some questions, and really, I just wanted to present that information to you all, that the State Board of Education states that the school's not on their list, but also the court ruled back during the time that Ms. Colvin was attending school that her parents were not violating the truancy laws that were on the books at the time in Tennessee. So. Let you all address the matter at this time.
You said that this school is not currently listed. Was it ever listed? Now, yes, sir.
Maybe I can add a little. That's what I'm here for, is maybe shed a little light.
First of all, the chair would recognize Ms. Colvin for response to that question. And then, Ms. Colvin, if you want someone else to speak on your behalf, if you would introduce that person, please.
Bob Young from here in Nashville.
Chair recognizes Mr. Young.
My understanding of what I have seen here is Ms. Colvin's application.
Excuse me, sir. We need the light to be on. Let me do one other thing.
Okay.
It won't record if we.
That's all right. I'll start back again. I understand that all of the applications are in before I became involved in this at any particular, and everything conforms. The only question appears to be the existence or non-existence of the school that she attended. What I have offered to your legal counsel this morning was a copy of a judge's ruling from Coffee County, Tennessee, which was a memorandum opinion and order from Rick L. Moore. It was dated November of 1982. Now, this was before Ms. Colvin attended the school, so her name was not as a truant on this, so she was not involved in this. 1982 is an important date here. The city brought charges against the children of the school. In essence, the children are not attending a recognized school, therefore they are truant. That might be a little bit of a stretch, Mr. McDonald. You're not looking for an argument. I'm just trying to say how I perceive it. Then there was the trial. The trial was the school was represented by Mr. Robert Husky of Manchester, Tennessee. After the hearings were all held, the order was entered by Mr. Rick Moore, who was the referee of the juvenile court, and he said that the children were not truant. Ergo, they can't be truant if they're attending a school. That's what it comes down to. So the letter that I presented to Mr. McDonough says, in essence, from Mr. Husky, I represented the school. We tried the case. The judge ruled in favor of the school, did not find the students truant. I also gave him a handwritten note from the secretary and one of the teachers in the school who also said that she remembered Ms. Colvin attending the school, was a good student, and was never truant in good attendance. Therefore, what I see here is the school is recognized by the state of Tennessee. Apparently, there's been the school was short-lived, and apparently some of the records and recordings that would be held in the Department of Education, State Department of Education, have been lost, mislaid, misplaced, and that creates the problem that has brought us here today. So obviously we submit that Ms. Colvin did attend. She did attend high school. She has graduated. I understand her diploma is on file and a copy of her transcript of her grades. So as far as number 4 under 625312, I think she has complied with it. So.
Board, I don't think there's any question about her attendance in the school or her grading sequence here or the copy of this diploma. I think the question is, Board, is whether or not this school was recognized as a provider of education by the state of Tennessee, and that would why 625312B4 is in question. Not that she attended school and not that she completed this school, but whether this school was recognized by the state of Tennessee Department of Education as a educational providing entity in our state.
Mr. President, if I may, in the hearing, the judge found that the children were not a recognized school. Am I right, Mr. McDonough? If they weren't attending school, then they would be truant.
They weren't attending school, then they would be truant, but I would also add that our communications with the Board of Education and with the State Department of Education found that they didn't have a record of the school, and so it wasn't recognized by them on that list. But I believe as he said, that the school was short-lived, and so that that may contribute to the fact that they don't have that information there. But all I can tell you is that from our communication with the State Board of Education and the Department of Education is that they don't have a record of that school.
That doesn't, and I submit, Mr. President, that doesn't mean the school didn't exist. That doesn't mean the school wasn't recognized at the time. That means that, to me, all that means is they can't find the records now, 30 years later.
How long was the school in existence?
Till 1995.
From 80?
From 1982 till 1995.
This was an accredited school from the state of Tennessee.
That's what I was told by the school.
I mean, I can't do anything about their records if they don't have them, if they're lost, misplaced, or stolen, and are we supposed to suffer because of that? That's
What years, Ms. Colvin, did you attend this school?
Graduated in 1984, and I went there half of my 10th grade.
So you attended there about 2.5 years.
You went to Coffee County before then, or?
Went to Franklin County High School
Franklin
in
County.
Winchester.
Okay.
Asked you a question that doesn't really, applied and used this diploma for any kind of employment or anything before applying for this? I know that's, would you care to tell me where
I would
the
love to.
businesses that accepted this diploma?
I would love to. I worked in the medical profession for about 20 years. That covered a lot of administrative work. I was a medical auditor during that time. Later became an agent with the U.S. government. That was my previous job before I applied for this. I still do have security clearance with the U.S. government Division of the Internal Revenue Service, and they accepted this diploma.
I'm sorry. Go ahead. Was there ever a question as to why your diploma was handwritten, your name and the date?
They put that on every one of those. I've contacted previous classmates, and that's what the school.
High school.
Remember exact from people that I've kept contact with and graduated with. There was probably about 15 to 20 I graduated with. It was a small, very small class.
President, one of the things that Mr. McDonough and I talked about too, you know, if the board should decide to approve this as a registration, then, you know, that still makes the applicant responsible to complete 30 semester hours at a school accredited by the American Board of Funeral Service Education. So that would be that doesn't do anything to change that requirement.
Ms. Colvin, have you made application to a mortuary school yet?
No, sir.
Plan to do that?
Motion to approve.
second.
Motion has been made by Mr. Hinkle to approve this apprentice application. Make sure I have that terminology right. Hold on just a moment. This is application for student registration application, apprentice application. Motion has been made by Mr. Hinkle, seconded by Mr. Starkey to approve this application. Is there any other discussion? All in favor, say aye. Aye. Any opposed? Motion carries.
May we have those documents for part of the file to substantiate? So when we get audited, we'll have some information and more additional information in the record. And I suppose it's okay with the board to approve that application retroactive to the date that all the requirements were turned in, as we would normally do.
Yes.
Okay. Ms. Colvin, we'll approve your application back to the date that the application and the documents that support it, we'll make it retroactive, so you won't lose any time in that.
Board members or the executive director or legal counsel have anything else to come before the board today? Hearing none, the chair will entertain a motion to adjourn.
So move.
Second.
Okay. All in favor, say aye.
Aye.
We stand adjourned.